Hello, thanks for joining us. Our recent article speaks to the need of fairness in the judicial, quasi-judicial, and administrative dispute resolution channel of Nigeria. It's our assertion that there should not only exist a tax dispute resolution channel, but also one embedded in fairness and justice delivery, which is a channel where the taxpayers trust its impartiality and independence of its processes, procedures, and decisions. A tax system is not complete without a well-structured dispute resolution mechanism, as conflict is bound to arise between taxpayers and tax authorities. The article is focused on the novel provisions of the TAT Rules 2021 and the Federal High Court of Nigeria Federal Inland Revenue Service Practice Directions 2021. The tax Rules 2021, which is an improvement on the previous tax rules, contains commendable innovations and makes provision for virtual hearings, case-stated procedure, documents only procedure, and summary appeal procedure. However, Rules 1 and 2 and 6 of the TAT Rules 2021 provides that a party aggrieved with a decision of the tax authority of the FIRS can file an appeal. However, the aggrieved party is required to pay 50% of the disputed amount into an account designated by the tribunal before hearing. The payment is intended to act as a security for prosecuting the appeal and effectively reinforces the pay now and argue later philosophy in the Nigerian tax dispute administration system. This pay now and argue later provision may create a concern for taxpayers, especially in view of the recent ruling of the TAT in the tax appeal of MultiChoice Nigeria Limited and FIRS, where the tax panel made an order for provisional tax to be paid by the appellant as a condition for continuation of the hearing of the appeal. A perusal of Form TAT 1B2 indicates that when this provisional tax is paid in designated account, receipt of payment is to be issued by the FIRS or any other tax authority, as the case may be. This creates a basis for assumption to be raised that the account for such deposit is to be made will be the account of FIRS or any other tax authority. The Federal High Court Practice Direction 2021 mentioned earlier contains provisions that have also raised a lot of questions. Order 3 Rule 2 of the Practice Directions empowers FIRS to file an ex parte application in the Federal High Court, praying the court to freeze an aggrieved taxpayer's bank account, confiscate immovable property, seal off premises, and access businesses' premises to search physical and electronic records without notifying the taxpayer. The direction also empowers the FIRS to have access to taxpayers' books, documents, servers, billing systems, bank accounts, including those stored in a computer in digital, magnetic, optical, or electronic means. The implication of this provision is that an order for forfeiture of taxpayers' assets or freezing of their accounts can be made without notifying them and without them exercising the right to put up a defense or to present an argument against such an application. The proponents in support of this model, that's as provided for in the TAT rules and also the Federal High Court Practice Direction 2020, they've opined that such provisions will compel taxpayers to become more compliant with tax laws and be more willing to cooperate with tax officials by providing documents during audits and investigations. To consider the fairness of the provisions in the TAT Rules 2021 and the Federal High Court Practice Direction 2021, we examined the practice in other jurisdictions and we focused on Tanzania, Uganda, and South Africa. In Tanzania, a tax objection will be admitted only if the aggrieved taxpayer within a 30-day window from the date of service of the tax assessment pays any part of the tax assessment which is undisputed or 1/3 of the assessed amount, whichever is greater. A taxpayer has the option to approach the Commissioner General to request a reduction or waiver of the mandatory deposits or to proceed to pay same. A request for reduction or waiver of the deposits can be granted by the Commissioner General if the aggrieved party furnishes compelling reasons. The practice in Uganda is somewhat different from that of Tanzania. Section 15 of the Uganda Tax Appeal Tribunal Act makes it mandatory for an aggrieved taxpayer to pay a deposit of 30% of the assessed amount before a tax appeal can be validly filed at the tribunal. However, the Constitutional Court of Uganda in 2020 held that the requirement to make payments of a deposit prior to institution of a tax appeal is unconstitutional because it offends the right to fair hearing enshrined in the Constitution of the Republic of Uganda. In South Africa, as we considered in the article, Section 164 of the Tax Administrative Act provides that when an assessment is reached, the obligation to pay the tax becomes effective and an appeal or objection does not suspend this obligation. Notwithstanding the above clarity in the South African position, it is important to note that payment of the disputed amount is not a condition precedent for initiating a tax appeal. We considered the implication of the model, which is pay now and argue later. The provision of the rule, which requires the aggrieved taxpayer to pay 50% of the assessed amount, will significantly affect the cash flow of businesses. It will increase the liability of businesses and hamper the ease of doing business in Nigeria generally. The provision will, in the long run, scuttle the growth of businesses, especially those with low margins and weak cash flow. It can also lead to job losses and closure of businesses. It may also affect the attractiveness of the Nigerian business environment to local and foreign investors and negatively impact our ease of doing business ranking. It can further empower tax officials to become arbitrary in raising additional tax assessments and push taxpayers to settle such arbitrary assessments with tax officials rather than appeal to the Tribunal of Federal High Court. Based on the foregoing, indeed, there is considerably a merit in the argument of both the proponents and opponents of the pay now and argue later rule. There is a need to adopt a more balanced model that factors the benefits of both positions and minimizes the demerits. We suggest that if the pay now and argue later model is to be implemented, checks and balances should be built into the system. For example, the rate of tax to be deposited should be reduced to a maximum cap of between 10 to 20%, and the applicable rate should be determined on a case-by-case basis by the tax appeal tribunal. The rules should also provide an avenue for taxpayers to be able to appeal against the decision of the tribunal with respect to the applicable rates in a manner that will not inhibit the hearing of the substantive tax appeal. Finally, the deposit should be paid to the tribunal to an interest-yielding account and not to the tax authorities to ensure fairness. To read more about our article, please visit our website and subscribe using the button below. Thank you!